afternoon. Welcome to this panel event on abolishing the death penalty in New Hampshire. My name is Marge Dropper, and I'm a member of the Biennial Symposium Committee. So this panel event is part of Keene State College's 8th Biennial Symposium. The theme of the symposium this year is Finding Your Place in the Evolving Commons. We hope with this theme to explore our understanding of and responsibility for those spaces and resources we share in partnership with others.
Thank you very much for coming out this afternoon. My name is Opal Johnson. I'm a faculty member here at Keene State College in the Mathematics Department, and I'm a member of a local group that is advocating the abolition of the death penalty in New Hampshire. It's called the Monadnock Citizens Concerned about the Death Penalty, and that is the sponsor of this particular panel discussion. We meet about once a month at the public library, Keene Public Library, and we'd love to have any of you who are here join us in those monthly meetings. There is currently introduced before the state legislature a bill to abolish the death penalty, and that will be deliberated and voted on this spring. And so we are working to see that that bill is passed and signed by the governor so that we become one of those states that do prohibit the death penalty. Before I introduce our panel members today, one of the things, person I'd like to introduce to us is Ken Arnold. Ken Arnold has brought a piece of work for us today, a piece of artwork for us to admire today. And I'd like him to say a few words about the artwork that he has for us on the theme of the death penalty.
I've always been against the death penalty, and about 15 years ago I started doing some artwork and fiddling around with twine. Twine is my gig. And so I was fiddling around with twine and I was making some nooses. And I thought to myself, what can I do with these nooses? And I thought, wow, I wonder about the United States, you know, what number of people that are being executed. And so I went, this piece of artwork up here is from the year 2010. And I went to look and see how many people were executed in the United States. And up there, there are white nooses depicting, in 2010, 27 white gentlemen and 1 woman who were executed. 13 black nooses indicating 13 African Americans who were executed, and 4 Latinos were executed. One of the people were executed by a firing squad in Utah, and one was executed by an electric chair in Virginia. In 2012, 2 years later, we executed 3 less people in the United States than we did in 2010. And this coming year, we have on the docket the possibility of 40 people being executed. So, slowly but surely, we're making increments on not executing quite as many people, but it is a very slow process.
Okay, now I'd like to introduce our panel members. First of all, to my right here, Pete Stevenson. Pete Stevenson is a professor of sociology and criminal justice here at Keene State College, and is the driving force behind first the criminal justice minor and now a criminal justice major here at Keene State College. In addition to his work in that field, he has had a brief tenure as a policeman and worked in probation as well.
I thought I would use this as a teaching moment to start with here. When I teach my Introduction to Criminal Justice Studies course, near the end of the section on the courts, when we start talking about punishment and sentencing, we go over a typology that's been around since the 1960s that looks at what do we want our punishment to do. Students in here will remember this as the goals of punishment. And there are 4 things that we look for our punishment to do historically. time period to time period, some are emphasized more, some are emphasized less. And I thought I would use these 4 criteria to talk about the death penalty and see how well it actually meets these goals. The 4 goals are rehabilitation, incapacitation, deterrence, and retribution. Those are the things that we look for our punishment to accomplish in some way, shape, or form. So when it comes to capital punishment, the first one I mentioned was rehabilitation. Are there any rehabilitative effects to using the death penalty? I would probably argue no, simply. And actually, I think if you offered programming and services to inmates on death row, I think a lot of taxpayers would say that's just a waste of resources for somebody that you're about ready to execute. And that's why, a lot of people on death row are sitting around languishing as the case maneuvers through the appeals process. And really, they don't get, much in the way of opportunity of programming that other inmates may get. So I don't think it accomplishes that goal very well at all. The next goal is incapacitation, and that is removing the offender from society so they pose less of a danger to society. I would argue that capital punishment is actually effective at incapacitation. It does remove the offender from society. But then the question, and this isn't in terms of moral costs, I think some of my fellow panelists will talk a little bit more about that. In terms of actual costs, using this form of incapacitation is probably more costly than sentencing somebody to life in prison without parole. Going through the appellate process is quite expensive as opposed to putting somebody in prison for life. So it does accomplish the goal of incapacitation, but I don't think it does it in a very cost-effective way, especially in a state like New Hampshire where we have to build a death chamber as well as other things to carry out the execution. So I'm not sure, and given the small number of people we have on death row and historically executed, I'm not sure that this is a form of incapacitation you really want to use. The next one's deterrence, and this is really why I sort of wanted to speak today, and that deterrence effect of capital punishment has often been used, especially in the state of New Hampshire, by law enforcement. They argue that having the death penalty primarily for individuals who kill police officers makes them safer on the job. Okay? That it provides a deterrence effect. If they'll think twice before they pull that trigger or stab the officer or assault the officer if they know that the possibility is that they could get the death penalty. And that's been used as an argument quite a bit in this state and actually other states as well for the death penalty by the law enforcement community. In some ways, this seems a little strange to me in that I grew up and come from Michigan where in our state constitution, the death penalty was abolished. We don't have the death penalty. Police don't. Being a former police officer in the state of Michigan, we don't talk about the death penalty. We don't want the death penalty. Some crazy politicians bring it up once in a while. We just kind of say, we don't care. It's just not a big deal in the criminal justice system for the death penalty. We don't really think there's any need. Nobody's talking about that being less safer. So there is this argument for this deterrent effect. Again, as another little teaching moment, there are really 2 types of deterrence. There's specific deterrence and general deterrence. Specific deterrence would be why we punish an offender, why we put them in jail, so they don't do it again. They do a stint in either on probation or they go to prison or jail, and that's supposed to change the calculation that they make in their head, and they won't re-offend. So this is not recidivism. The other deterrent effect is general, and this is sort of where we get into the idea of capital punishment, that if people know that capital punishment is out there, they will be less inclined to commit a murder if that's one of the options on the table. And in New Hampshire, it seems to only be an option when you kill a police officer, is sort of the argument. So we are arguing for this very sort of centralized general deterrence effect here. Overall, with deterrence, there are a couple of issues, and I won't dwell on these too long because I want other people to have a chance to speak. But there are really methodological issues with looking at deterrence deterrence effects, in terms of how do we do research on that. And there are also theoretical issues, some of the theoretical ideas behind deterrence that are problematic. First, the methodological issues. It's very difficult to measure the deterrent effect of the death penalty. And that one, it's not, even though some states use it quite often, and people would think, Texas would be the model of deterrence. If it's really going to work, when we do research in Texas, we really should see a deterrence effect. And that's just not the case. Yes, there have been some studies that show a slight deterrence effect, and there have been just as many that don't show a deterrence effect. And that's probably due to the just methodological difficulty of doing this. There are a lot of variables that you have to control for to try to determine the deterrence effect. Yesterday I was talking to one of my colleagues who happens to be a political scientist, and he's like, oh, it's easy to measure deterrence. You just compare a state that has one versus a state that doesn't. You look at the murder rates, and there you go, boom. And no, it's not that easy. I wish it were. But you need to control for things like the plea bargaining process. Some people's plea bargain down to lesser sentences. There are also not gender effects, there are racial effects that you need to control for. And all these things need to be controlled for before you can really look at the deterrence effect. And that's just tough to do. If somebody wants to talk to me more about actual methodological issues, I'll go into a lot more detail at a different time. The other one is a theoretical issue that is at stake here. Most of our legal system is really based on sort of utilitarian philosophy. Jeremy Bentham, I don't know if you know who he is, but he's sort of the founder of utilitarianism, and he's one of the people responsible for the idea that the punishment must fit the crime kind of thing. And he also argued for, one of the things we want our law to do is have this deterrence effect. If the punishment is severe enough, people will change their calculations and then they won't do it again. Or if they think they're going to be punished, they won't do it again. Or they won't do it in the first place. So utilitarianism is based on the idea that individuals are rational actors. We weigh our costs and benefits before we do that. For those of you who have maybe had an economics class, they talk about people acting in their long-term self-interests, and that they think about the long-term consequences of what they do before they do it. So they have an understanding of what the consequences are. And a lot of our legal sort of premises we have in this country are based on utilitarian ideas. And at least among criminologists, we're pretty much in agreement now that this is probably a bad place to start, this theoretical idea that people are these rational actors. Generally, what we find in our research, people are rational actors. There's a term we use called bounded rationality, where that given one's social context, reality is sort of locally determined. So they may be in a situation from our vantage point that looks totally irrational to us. For example, in my criminology class, I usually talk about a study about residential burglars, and they use this bounded rationality idea to try to explain what goes on with residential burglars. And one of residential burglars' primary motivations is what they call to keep the party going. They want women, liquor, and drugs. That's why they break into houses, because they want to do that. For us, that looks like a stupid thing to waste our time, effort, and risk jail on, right? But for them, it's at the top of their list. It seems very rational to them. So that extending this into the death penalty, to think that before an offender, lashes back at a police officer, fires their gun, whatever, that they're going to go through this calculation through their head, I think is quite sort of misguided. We don't always act that rationally. So, and deterrence tends to break down if we recognize that people aren't always that rational. So again, I'm not sure that in terms of meeting these four goals that I talked about, you really get a good deterrence effect. One, that it's methodologically difficult to determine if there is an effect, and it's built on theoretical premise that's problematic. Okay? The fourth one I want to talk to is retribution. And at least in my mind, and here we're talking sort of Old Testament kind of retribution, eye for an eye kind of thing. I guess if you're going to use any justification for the death penalty, I'd say that's probably it, if you're going to do that. But then again, and this gets more into sort of morality and theologian type issues that I won't get into. I think even then, the idea that at least the way we enact the death penalty in this state, that we use it so infrequently, and we only feel like those who really deserve this very grievous punishment are those who kill a police officer, I think it is slightly misguided. Now, don't get me wrong, I'm not suggesting that we really should go out and start executing lots of people in the name of retribution. But I think even there, does this really satisfy people's needs for retribution? I'm not really sure about that. And it seems just silly to say that, in some ways, the way we do this in this state, it's suggesting that a police officer's life is somehow more worthy of his, getting an offender getting this punishment than if it's an ordinary citizen. And that just doesn't make sense because it's somebody who comes from somewhere else other than New Hampshire. But I understand it's a very strong feeling. And I actually wish the law enforcement community would sort of move off the deterrence argument. And if they want to make this argument, I think they should make it, because I think that's really what they want to do, is that they want to say, you kill a cop, you deserve to die. And those were the exact words that, when she was governor, Keene used to me my first year here at Keene State when she was campaigning. And a colleague and I walked up to her and started asking her questions after an event, and we both said we were disappointed that when she had the chance to outlaw the death penalty, she didn't do it. And her only response to that was, you kill a cop, you deserve to die. And I just, okay. It just seemed sort of strange, the idea that, we're going to enact the death penalty pretty much to kill sort of a police officer's name. I'm not really crazy about them killing in my name either, but to say that, we're going to do this just for police officers because they deserve it more than if they kill somebody else seems to be kind of silly. So this selective application of retribution doesn't seem to make sense to me either in terms of meeting these goals of punishment. So basically, to sort of quickly wind up here, is that I really don't think this is an effective punishment. It doesn't do really anything that we want it to do. So, I think, why use it? And I'll kind of leave it there.
Next, we have Reverend Mark Jenkins. Reverend Jenkins is the rector at St. James Episcopal Church here in Keene, and has advocated for a number of causes, including the abolition of the death penalty.
My name is Mark Jenkins. I'm the rector of St. James Church in Keene. I'm smiling because I'm the second Michigan person to speak. It starts to feel like we're on a mission here. I came here about 3 or 4 years ago from the state of Michigan, and was actually commenting to someone this morning that this is a conversation that's just not been a part of my life prior to coming here, because Michigan was one of the first governments in the Western world to outlaw the death penalty. We did that in the 1860s. And so it just hasn't been a part of the conversation there the way it has been since I've come here. Nonetheless, because we live in a national culture, we have had the opportunity to have those conversations, just not perhaps about the home field. I was fortunate about 20 years ago to meet a woman whose name was Marietta Yeager. I don't know if anyone here has heard of Marietta Yeager or not. But I'm going to share with you her story. I'm a preacher, and preachers tell stories, and I find that to be an effective way to engender conversation. It is my experience that Marietta's story is not an unambiguous story, and that's one of the reasons I think it's helpful to get us thinking about this today. In 1973, Marietta Yeager's daughter Susie was abducted while their family was on a camping trip to Montana. In the middle of the night, while everyone slept, Susie was taken. The tent was cut next to her head, and she was pulled out through that opening, and she was carried away. Susie was 7 years old. For over a year, Marietta and her family had no word on where Susie was, or of whether or not she was even alive. As she described it on the website Journey of Hope, which is an organization that she later helped to organize, shortly before the one-year anniversary of Susie's disappearance, Marietta stated to the press that she wanted to speak with the person who had taken her child. On the anniversary date, she received a call from a young man who taunted her by asking, "So what do you want to talk to me about?" During the year that had followed Susie's disappearance, Marietta had struggled to balance her rage against her belief in a need for forgiveness. During that year, she has written, "I had worked diligently to come to a healthier attitude than rage and revenge. I reminded myself that however I felt about this person, in the eyes of the God I believed in, he was just as precious as my little girl. So I asked him what I could do for him. He broke down and sobbed heavily. Our middle-of-the-night conversation lasted for 80 minutes. When the call finally ended, I was left hanging on to a silent phone." The kidnapper subsequently revealed enough details about himself and about his crime that the FBI was able to apprehend him and to solve the case. Marietta learned that her daughter Susie had been killed on a remote Montana ranch a week after she had disappeared. Despite her family's tragedy, she remains committed to forgiveness and has been an ardent opponent of the death penalty for the now 40 years since Susie's death. It is a horrifying story. I have 2 children of my own, and I can't begin to imagine what she and her family must have gone through. But here's the grace in all of that pain and suffering. Listen to what Marietta had to say. "Loved ones, wrenched from our lives by violent crime, deserve more beautiful, noble, and honorable memorials than premeditated, state-sanctioned killings. The death penalty only creates more victims and more grieving families. By becoming that which we deplore, people who kill people, we insult the sacred memory of all our precious victims. That kind of justice would only dehumanize and degrade us because it legitimates an animal instinct for gut-level, bloodthirsty revenge. My own daughter," she says, "was such a gift of joy and sweetness and beauty that to kill someone in her name would have been to violate and profane the goodness of her life. The idea is offensive and repulsive to me. Capital punishment degrades, dehumanizes, and debilitates us as a human society." Now, I cannot personally imagine doing as Marietta Yeager has done. The strength of her conviction is so far beyond me that I am not even sure I can bring myself to wish that I had that kind of commitment. Such a commitment to the one that I have, in a very visible way, given my life to following. Commitment to Jesus, who is the person that I follow. A commitment to a Jesus that has called me and others to love without condition, to love without reservation. That's what I, as a follower of Jesus, believe that I have been told to do, to love my enemies. Love your enemies, Jesus said, do good to those who hate you. I said I'm a preacher, and I know full well that there are so many things that Jesus said that are not clear and are hard to understand and don't seem always to make sense. But there's nothing in those words that strikes me as particularly unclear. Love one another. Forgive your enemies. Those are bedrock, fundamental imperatives. In my own tradition, the Episcopal Church, we first went on record in opposition to the death penalty in 1958. That's the year I was born. This is not a new conversation for us to be having. I am fully aware that the Christian church, for many, many centuries, not only supported the use of the death penalty, but actually demanded it. I ran across yesterday, as I prepared for this, something I'd never known before, which is that apparently in the 17th century in the state of Virginia, if you missed church 3 times, the church could demand the death penalty. That would have a chilling effect. It's clear that through the history of the church, we have not perhaps been captive to our better angels. We were not being true, I think, to the mind of the one that we follow. It was no small irony, I think, that the church was actively engaged for many, many centuries in imposing the death penalty when we were a church that followed one who himself was executed by the state for crime. We seem to have lost sight of that. Fortunately today, many churches and other religious have found themselves coming to a renewed understanding of the real world implications of our obligation to respect all human life and to always stand ready to forgive even the most heinous of actions. And those numbers, I am delighted to say, are growing, always growing. There are many reasons, ultimately, for opposing the death penalty. Pete's done a good job, I think, of giving some of them. I think from a religious and moral perspective, there is, of course, the concern for the sacredness of all life, and not the least of which human life. There are inequities that we are all aware of, I think, have been demonstrated amply, inequities within our system that lead to a gross overrepresentation of minorities on death row, which bring into serious question the legitimacy of the manner in which this is implemented. There is the fallibility of our systems of justice that we see with a somewhat regular basis. There is a lack of evidence to support arguments of deterrence, I think. And there is, as Pete pointed out, I think, a subtext of retribution that is unacceptable in a civilized society. We talk about deterrence. What we want is vengeance. I think we have to be honest about that. Because only if we're honest with that in front of us are we enabled to really engage in an honest conversation about what we're doing. The violence of the act itself infects the society. But for me, I keep coming back to the words of Marietta Yeager. I say there is no amount of retaliatory deaths that would compensate to me the inestimable value of my daughter's life, nor would they restore her to my arms. To say that the death of any other person would be just retribution is to insult the immeasurable worth of our loved ones who are victims. We cannot put a price on their lives. Richard Holloway, the retired Bishop of Edinburgh in the Scottish Episcopal Church, wrote a book called Doubts and Loves, and he has written that he thinks forgiveness is perhaps the most distinctive of Jesus' teachings. In a chapter devoted to the subject of forgiveness, he points to, quote, the model prayer that Jesus taught to his disciples, in which they were to say, forgive us our sins as we forgive those who sin against us. Holloway goes on to say, without radical forgiveness of one another, we condemn ourselves not only to the pain of our offenses against one another, but to years of misery that deepen the original wound by the corrosions of bitterness and hatred. And this is true not only of individual trespasses against one another, but of the sins of whole tribes and nations. Let me conclude with the ancient proverb, he who seeks revenge digs two graves.
Ray Dodge is a retired police chief from the area and has been very active in the state and beyond in the fight to abolish the death penalty.
My name is Ray Dodge. I am a retired police chief here in the state of New Hampshire. I worked for 25 years total in the state in various law enforcement capacities. The last 8 years, I was the police chief in a little town, and some of you may know around here called Marlboro, just a little bit east of here. Terrific community. I can't sit here and say to you, with all honesty, that I have always been in this position where I favor repeal of the death penalty. I think certainly early on in my career, I probably would have told that company line, so to speak, with all police officers, and that, well, we need the death penalty. It's what keeps us safe. It's what keeps people from committing crimes. The problem with that was I didn't really have information. I really hadn't thought this through. I just generally accepted, I think, what was told to me and what was taught to me. As I evolved through that career, one of the things, and I guess my remarks would be a little bit in a different perspective from the previous two speakers, is that the criminal justice system is a system that's designed by human beings and is run by human beings. I certainly am far from perfect. I like to think that I gave every case that I did, every case that I prosecuted. I gave it my all, did my best work. But I'm not naive enough to know that I make mistakes. We all make mistakes. And that is certainly true in the criminal justice system. I made mistakes throughout my career. Fortunately, for me, it never put anybody on death row. The other thing about the criminal justice system is that it is very subject to judgment calls. When you start talking about who's going to be prosecuted, it's one thing to have a law that says if you kill a police officer, you will receive the death penalty. But it is actually quite possible that the people who make those charging decisions may look at that case and say, we just don't have a strong enough case here to go that far. We're not going to seek the death penalty. That might be one reason why they do it. There might be other political reasons why they decide whether or not they're going to seek the death penalty. Certainly some of the best examples of that would be from Chicago and the Illinois areas from the late 80s to the early 1990s. We had a gentleman here in the state a few years ago who was the product of that system, who was put on death row primarily because it was just a political thing with people that make the charging decisions. In that, it was a very gruesome murder. and the public wanted this case solved, and they wanted it solved in a half an hour with 2 commercial breaks. That puts a lot of pressure on those who have to make that charging decision. When they've got people knocking at their door, when are you going to do something about this? When are we going to get an arrest? It puts a lot of pressure on them. So they feel like they have to come up with something to back the people down. And that's where the political system creeps into this whole process. I'm not certain. I mean, for me, first of all, on a personal level, I'm just morally opposed to the death penalty. We've gotten a little bit into the spirituality here. I'm a Unitarian. I'm a member of the Peterborough Unitarian Universalist Church. I've been a member for many years. And one of the principles of Unitarianism is that we respect all life. I'm not sure that as a police chief and as somebody that has worked in the criminal justice system, that somebody's life should have to depend upon somebody else's making a decision that really is an imperfect decision. They're a human being. They have their perceptions, they have their perspectives, and they have that potential influence coming from all different angles. Certainly I know as a chief, it was always said to me throughout my law enforcement career, the best position in any police department is the second in command. Because the only guy you got to worry about is the guy at the corner office, the chief. And yeah, maybe you got to worry about the officers on the street too. When you are the chief, you've got it coming from every angle you can think of. You've got it coming from your constituency, you've got it coming from the bosses, you've got it coming from your officers. A tremendous amount of pressure. And I'm just not comfortable knowing that those people with those kinds of issues and those kinds of pressures are going to make a decision that might take somebody's life. In addition to that, you have the possibility of a mistake. And you make that mistake, and then you push this system, you push that case through the system, and then that person is executed. And that has happened. There are documented cases out there where people who were executed have now been determined to be falsely put to death. That to me is just, I just have a real issue with that because I just don't believe that we should be executing people based upon people's judgment calls. One of the things about deterrence, let me touch on that a little bit since that's kind of sort of talked a lot about. And let me take that to a different level. To me, deterrence actually starts when a person is born. One of the other issues with the death penalty is, for me, is the cost of the death penalty. And having done some studies on that, New Hampshire, for example, on average, it's about $35,000 per year to keep an inmate at the state prison in Concord. So if you want to start looking at cost, then you have to make some assumptions. The average person that goes on death row is usually about age 29. The average length of an adult male, and let's face it, 98% of the people on death row are are males. The average age they live to is 77 years old. So when you start crunching those numbers, it's probably going to cost the state of New Hampshire about $1.6 million over the course of that lifetime to keep that inmate in jail, in prison. Currently, the Michael Addison case, of which we have numbers, has cost us about $5 million. That includes the cost to prosecute the case, the cost to defend Michael Addison, the cost for the courts to hire additional law clerks to do the research, the additional time that's been involved with the courts to process this, and we're not done yet. And that also includes, just escaped my mind, but the cost, $5 million to get back to the deterrence factor. Wouldn't it be better if we could use that money and put that back into our mental health systems, which when you look at a lot of the people that are on death row, they have mental health issues, mental health illnesses. I think in this state, in the past few years, unfortunately, we have cut a lot of the money to mental health programs. These people have essentially just been pushed right back out into society, and almost, we've said, you're on your own. I just happened to watch a movie tonight that I like called Forrest Gump. And, you know, that's sort of what we're looking at here. These people are now out there, they're kind of on their own, they don't know what to do. When it comes to that decision, do I, don't I, they don't really have that capacity to be rational in that. And these are the people that are winding up on death rows across the country. So when you talk about cost, when you talk about deterrence, for me, I think deterrence begins way before these people have even started to engage in their criminal activity. And I think it would be much better for us to take that money and put that back into the mental health systems, get these people the help that they need, and I think in the long run, not only would we see murders go down, but we would see a lot of other crimes go down. One other area I want to talk about on the deterrence factors, and I have some information here. You can certainly get this on the Death Penalty Information Center. It's, the website is deathpenaltyinfo.org. It's DEATHBENALTYINFO.org. And one of the statistics that I've seen over and over and over again when he talks about deterrence is that the South, which is pretty much like what you would consider the Bible Belt, Florida, Texas, Virginia, which are the actually 3 states that do the most executing, also have some of the highest homicide rates in this country. Certainly, as the professor suggested, be careful when you start getting into numbers. But then when you look at the Northeast, which is where we're at, in New England, the only state now that has the death penalty is us, New Hampshire. Connecticut repealed theirs 2 years ago. That also includes the state of New York. That also includes the state of New Jersey. I believe the state of Pennsylvania has a moratorium on the death penalty, though they still do have the death penalty. But the Northeast, which would also include cities of Boston and New York, Worcester, Springfield, Hartford, have some of the lowest homicide rates in the nation. So let me just end by saying that I think when you look at the criminal justice system, as good as it is, and it is good, and I worked alongside some of the best people that this system has, as good as it is, it's good because when mistakes are made, we can correct those mistakes. We can set these people free and do what we can to try to give them at least some semblance of their life back. The death penalty destroys that safeguard.
Rich Guerriero has been a public defender on death penalty cases in Louisiana, and here in New Hampshire, he was one of the attorneys on the Michael Addison case a few years ago. He is no longer a public defender, which allows him to speak more freely, but he's still a lawyer, and he currently is involved in a murder case.
Okay. My name is Richard Guerriero. I'm an attorney here in Keene, and I'm not going to address any of the academic or philosophical or research issues because that's not what I know about. I've been a criminal defense lawyer for 29 years, and I've handled death penalty cases in Louisiana for the first part of my career, and now in New Hampshire since 1994, whatever that is, almost 20 years. And what I thought I would do is give you a little bit of background about myself so that you'll know who you're hearing from, where my opinions and my thoughts come from, both in terms of judging what I have to say and asking any questions. And then secondly, give you a real crash course in how the death penalty actually functions in this country. My experience is that most people have no idea how it actually works. Actually, my experience is that most lawyers have no idea. In fact, I would tell you that there's probably about a dozen lawyers in New Hampshire who could actually sit down and describe the system for me. Maybe more, maybe 20 lawyers in New Hampshire out of 3,000 or 4,000 lawyers. So while it's important to consider the ultimate issue, I think when you're thinking about, well, does what we have work? Do I want to have this? You ought to know what we have. So that's what I'm going to talk about. Just briefly, I went to Louisiana State University for undergraduate and for law school, and I actually quit law school when I was in law school after my first year and said, I can't stand it. I can't stand being around all these people. They have these pointless arguments. And I went to go major in philosophy to get a master's in philosophy, and my philosophy professors grabbed me by the ear and drug me back to the law school and unresigned me because they said, you're being an idiot. And about that time, maybe a week later, I started working for some lawyers in Baton Rouge that did a lot of anti-death penalty work, did a lot of criminal work in general. And I found what I loved. I found a life practicing law that didn't involve the books nearly as much as it involved talking to people, interviewing people, investigating cases, and trying to decide what actually happened. And I stayed in law school and went on to become a criminal defense lawyer. When I was in Louisiana, at the beginning of my career, I was a private lawyer that also handled court-appointed cases. And I can't speak necessarily accurately for right now, although I think I have pretty good information. I can tell you back then that when I was barely 3 years out of law school, I was appointed to handle a death penalty case where the defendant was from New York State. He was accused of murdering a local resident in Natchitoches, Louisiana. He was tried in front of an all-white jury in Natchitoches, which, if you've never been there, and you talk about the Old South, the brick courtyard in the center of the town dates back to the early 1800s. I mean, it's the Old South, and here I was, 27 years old, all-white jury, black defendant, his family from New England down there, and you can guess what happened. He was sentenced to death. And it was only through legal maneuvering later at the Louisiana Supreme Court and in the federal courts that we were ultimately able to prevent him from receiving the death sentence. So that was kind of my introduction, and I handled a number of other death penalty cases in Louisiana, and then I came up here, and I've worked on 3 cases since I've been here. The 3 cases were the Gordon Perry case, which a lot of you probably won't remember, especially younger people, but that was in 1997, 1998. It involved the murder of a police officer, Jeremy Sharon, from Hillsborough. I worked on another case where it was a multi-state case where a defendant from New Hampshire faced the death penalty in Florida. And then I worked on the current Michael Addison case for the last 6 years. That's my background. I've represented 6 people that have faced the death penalty. None of them have been executed. When I was working in Baton Rouge, my partner represented a man named Jimmy Glass. And you can look up his United States Supreme Court case. And he was executed in spite of everyone's best efforts in the mid-1980s. The U.S. Supreme Court opinion describes his execution. It was one of the last executions by electrocution. And I was at Angola State Penitentiary that night for that execution with my partner. So, without going into more detail, I mean, I've been to the prisons, I've met with the families. I guess the other thing I will tell you is that I have a family member and friends who have been victims of homicide. And I have family members in law enforcement. So, believe me, and I've driven the car to the funeral with the widow in the car. So, I've seen the other side as well. And honestly, I think about these things in very practical terms and in terms of the people involved, and not as much in terms of the philosophical things, because I get attached to the people, to the victims, the defendants, the witnesses, everyone involved. So, how does a jury decide to sentence someone to death in the United States? What I'm going to give you is sort of a summary that mushes the procedures of all the states together, even though each state varies. Up until 1972, it was pretty simple. They had a murder trial. If the guy was convicted, they told the jury the possible sentences in most states, and the jury said, 99 to life, or death, whatever. It was completely unguided, which turned out to be the problem with. It was unguided discretion of the jury. And then a case came along in 1972 called Furman versus Georgia at the United States Supreme Court. And what the defendants challenged in that case, it was actually a group of cases, was this unguided discretion, that they said you're just sentencing people to death without any particular basis or any guidance for the jury. And coincidentally, that case in 1972 occurred at a time when support for the death penalty was at its lowest that it had ever been for decades. And in fact, right now, we are almost back to that level. But between 1972 and now, there's generally much more support for the death penalty, and we've sort of gradually, in the last 8 or 9 years, inched back down. So in some ways, where we are now is very similar to 1972 when the Furman case came out. The United States Supreme Court says in Furman, wait a minute, you can't just tell the jury, here's this fellow, you found him guilty of murder, decide whether he lives or dies. You've got to have some better standard than that. A lot of people interpreted that decision as outlawing the death penalty. You'll read newspaper articles that say the United States Supreme Court outlawed the death penalty in 1972. That's not true. They said you just can't have it without some standard. 4 years later, in Gregg versus Georgia, the Supreme Court considered the new standards adopted by Georgia and other states. And again, they varied. And the Supreme Court said in Gregg versus Georgia, okay, you've adopted a system that we think satisfies the Eighth Amendment prohibition against cruel and unusual punishment, the due process protections against arbitrarily taking someone's life. We think you've done enough. And so they said, we approve of this system that mostly that Georgia has. And they let Georgia go ahead with death penalty cases according to that system. So what we have as a result of that right now is a system where in every death penalty case, you essentially have two trials. You have the sort of trial that you would think of if you just studied basic government. You know, the jurors are called in, they select a jury of 12 people, the state presents evidence of whether the person committed the crime, the defense cross-examines those witnesses and maybe calls some witnesses, and they argue about whether the person's guilty and determine, whether he's guilty or not of first-degree murder. In a death penalty case, there's actually a second trial attached to that. And the second trial determines whether or not the death penalty is imposed. And the way they determine it in almost all states is through the consideration of mitigating and aggravating factors. And this part of the reason there's so few lawyers understand this area of the law is that it's incredibly complicated. According to U.S. Supreme Court case law, the factors have to be spelled out carefully. The legislature has to adopt them. If they adopt unconstitutional factors, they're invalid. And they have the system of aggravating and mitigating factors has to accomplish two goals, according to the U.S. Supreme Court. It has to, A, provide some guided discretion so that only the people that are guilty of, quote-unquote, the worst murders are going to get the death penalty, and B, so that the individual characteristics of a defendant might be considered. So, for example, that if you had two defendants that commit more or less the same horrible murder, but one has an IQ of 71 and was abused for the first 15 years of his life, and the other guy is a white businessman with an IQ of 169 and worth $5 million, those people aren't going to compare the same. So you've got to be able to compare their individual situations as well. And what happens in any death penalty case is that if the person is found guilty of capital murder, then there's the second trial where the state tries to prove aggravating factors, defense has to prove mitigating factors if it can. Sometimes there are not very many. And then the jury is instructed to, quote-unquote, weigh those aggravating and mitigating factors against each other and make a decision about whether or not to impose the death penalty. Interestingly, I'm going to make a few comments on the system now. Interestingly, although jurors are required to find beyond a reasonable doubt that the person is guilty of the capital murder, they're not required to find beyond a reasonable doubt that the aggravating factors outweigh the mitigating factors. They just sort of are presented with these things, and they're told, if these, you weigh these factors, and you weigh them however you want, as long as you're, following the court's instructions otherwise. And if you think it weighs in favor of the death penalty, you can impose the death penalty. So, number one, there's not really a test for reasonable doubt. Number two, as far as who is doing the weighing, at the start of the procedure, when you go back to jury selection, before you even have the trial on the murder, everyone who's opposed to the death penalty or says that they could not consider imposition of the death penalty is excluded. So none of those people ever make, so you have a jury deciding guilt that only includes people that would impose the death penalty. They don't have to say they would do it in every case or in the current case, but they have to say they believe in the death penalty law. And then that's who you get on the jury. So everybody that's opposed, unless they broke the law and lied and sat on the jury, and there actually are people around the country that sometimes advocate for that, but unless they broke the law and lied and they're on the jury, everybody on the jury is someone who favors the death penalty in at least some cases. And they make that decision and decide whether or not to impose the death penalty. That is usually in the first couple of years of the case. What happens after that is that the case is then reviewed by the state Supreme Court, whatever state it's in. And the court is required to do certain things. They're required to determine whether or not the penalty was imposed under the influence of an arbitrary factor or passion or prejudice. The classic example being racism. Or it could be something else as well. They're required to determine whether there was sufficient evidence to support the aggravating factors. And they're required to consider any other factors that may have influenced the sentence and made it unconstitutional. So you can imagine with this kind of limiting framework that, at least I would thought in law school, well, the law must be pretty much the same in every state. But it's not, because that's not what the Supreme Court required. They just said you have to have this basic system. So just to give you a very current example, Michael Addison, who I represent and I'm not going to make too many comments about his case because we still have another part of the appeal, but an uncontested, a known part of the case is that the jury in his case found that there was no purpose to kill the police officer, and the jury found that the government did not prove that he was a future danger. So with those findings, he would not be eligible for the death penalty in Texas, which we think of as sort of the prototypical death penalty state. That you're going to get it anywhere, you're going to get it in Texas. And it's not because New Hampshire has a broader system than Texas. It's just because we have a different system. And according to our Supreme Court yesterday, it's a valid system. But it's just to illustrate for you how different the systems can be. There are many, many Texas cases where the defendant would not be eligible for the death penalty at all in New Hampshire. And as it turns out, that at least our current case would not be eligible for the death penalty in Texas. So I make that point, sort of bring it back to my original point about my experience, that you have a real lack of uniformity in terms of how these cases are handled. You don't have uniform state laws, even though they're purportedly following the same principles from the U.S. Supreme Court. And you don't have uniformity in the experience and the ability and the resources of counsel. To compare to the case that I handled in Louisiana 3 years out of law school, in the Addison case, we have been adequately funded. We had less funds than the prosecutors, but still we were adequately funded. We had the investigators we needed, we had the resources we needed, we had 3 lawyers, we had what we needed to handle that case, I think. I wouldn't say that we lacked for resources. We had other complaints, but that's not one of our complaints. Compared to Louisiana, inexperienced people. I had another case in Louisiana where I was appointed by the court, was told that I was going to be paid, and not only was I not paid, but I was not reimbursed for my $1,500 of expenses in the case. And to give you an idea, a normal case like this, at an hourly rate, at a very reduced hourly rate for a lawyer, you're talking tens, if not hundreds of thousands of dollars. we've spent thousands and thousands of hours on the Addison case. The cases I handled in Louisiana were all probably not so many hours, because there the cases go to trial really fast. But still, you're talking about 1 or 2 lawyers at least doing nothing but that case for 6 months. So you can do the math at 8 hours a day. It's simply not comparable. The next to last point I want to address is that, is to touch on something Ray said. Well, first, he's correct that most New England states don't have the death penalty, but it's not that New England doesn't have the death penalty. The federal system does have the death penalty, and there, because one of my clients from New Hampshire also had a Massachusetts case and was sentenced, and I didn't handle it, but was sentenced to death in Boston, Gary Sampson. And that penalty was reversed, and it's now headed for retrial, I think. I don't know, I don't represent him on it. So in federal court, you still do have the death penalty in New England, and there's a pretty active prosecution of death penalty cases up in Berlin, believe it or not. You would think of Vermont as the most liberal state, but actually in federal court up in Berlin, they pretty routinely have a federal death penalty case pending. I can think of 2 or 3 in the last 10 years. So, we have it here. The point that Ray touched on, that error is inevitable, as someone who participates in the system, I can tell you that everybody recognizes that. If you look hard, you can actually find a quote from Justice Scalia in which he says, look, we've got thousands of death penalty cases. As Ray points out, human beings make these decisions and engage in these procedures. There are going to be mistakes. That's the nature of human business. So here we have, putting aside values and just talking about intellectuals, one of the intellectual giants of the U.S. Supreme Court, a very powerful figure at the court, a very smart man who's been there a long time, who has a huge influence over the justices on the court, saying, hey, you want to have a death penalty system with thousands of people in it? The cost of doing business is that some innocent people are going to get executed. That's inevitable. That's what I wanted to do, was to give you sort of a practical background, and I don't know if you guys have questions about how it works. I've taught courses on parts of this, so it's impossible to give you a summary in 10 or 15 minutes.
And then we'll open it up for any questions and discussion, comments that people want to make. Yeah.
One of the things that you mentioned about was how do we research the punishments? But isn't there also a lot of studies available right now on research, such as whether the death penalty really does deter and so on and so forth?
There are a lot of studies, and I will say there are 2 waves of studies. There are studies done by criminologists that we pretty much, as a criminologist, we pretty much stopped doing those studies in the early 90s because it's kind of settled for us. We really can't find a strong deterrence effect. Then for some reason, economists sort of picked up the mantle and started looking at the death penalty. Nothing against economists, but if anybody uses rational choice theory, they're the ones who do it. So their reviews are always based on this idea that people are rational actors. And even there, they don't find a particularly strong effect. There was a recent one in Texas that found a very slight but statistically significant deterrence effect. But I don't think not enough to really warrant it being used.
So,
I'm not going to give a speech, but let me stand over here so people can hear. I wanted to ask about your comment, Chief, that, well, first let me say I appreciate everything you all have said, and I agree that death penalty is not a deterrent. I'm a Unitarian too, and I'm firmly committed to the worth and dignity of every person. But your comment that we should put the money into mental health, and that we would then see the murder rate go down. My understanding is that people with mental illness are more often a victim of crime than a perpetrator of crime, and the percentage of people with mental illness who are perpetrators is less than the percentage of the general population. So I would think we should put the money into, poverty, into education, especially early childhood education, parenting, and yes, we should also be doing much better in supporting our mental health system. But I just worry about thinking that, as Kelly Ayotte seems to think, oh, we'll put a little money into mental health and that'll take care of it. No.
No, and I didn't mean to suggest that that would be the cure-all. That was just one area where I do believe that if we spent, if we did better at, I think that would have an impact. One of the things that we are seeing coming out of these mass shootings, particularly like the Newtown tragedy a year or so ago, is there were some mental health issues that were there. And I don't mean to suggest that we're going to prevent every crime. We're not. It's just not going to happen. As long as there's 2 more human beings on the face of the earth, there's the potential for crime. But I also agree with you. I mean, when you look at a lot of the people that are on death row, very few of them, I think you could say, come from affluent backgrounds or backgrounds where, I mean, the vast majority of them are people that grew up in poverty situations, their home life probably as they were growing up was traumatic, I guess. And there's no support system there for them. I think a lot of these people, one of the things about deterrence is somebody has to know the difference between right and wrong. And I think when you look at a lot of those people, I think they have a hard time with that because they've never been from an environment where it fosters that. And nobody's really taught them. I've always believed in the saying that it takes a community to raise children. And I believe that's true. I do.
Thank you.
Hopefully that.
Thank you.
Great, yeah, I just want to comment on that. I think it would be good for me to tell you my experience with that sort of thinking with jurors in capital cases, because it surprises me every time, but this is true. Jurors deciding whether to impose the death penalty don't care much about that stuff. And I'll give you a couple of examples, but basically the thinking is, well, look, this guy, he has a driver's license, he knows enough to know that he wants money to buy the things that he wants for himself. He knows enough to go buy alcohol or to buy drugs. He's able to walk around and function and get the things that he wants. And, while we might be sympathetic about his background, there's certain behavior that we're just not going to forgive you for. And I'm not saying that's my view, but my experience is that, you can open up the Union Leader any day and look at the comments section and you'll see it, that people call it the abuse excuse. That the jurors don't care about the background. Not enough to say that it makes a huge difference. They'll consider it and they'll apply the law as they're required to apply it. And these are rational, good people trying to make a decision, and their feeling is, look, I know somebody that grew up with a bad background, whose father was abusive, who was exposed to drugs and in a bad neighborhood and saw lots of crime. And he didn't grow up to be a violent murderer. So why should that be a big factor in this guy's case? And to compare, just in terms of what makes a difference to people, the single biggest factor, and this again, my practical point of view of trying to prevent the death penalty from being imposed, what makes a difference is if the juror has some doubt about whether or not the person is actually guilty of what they're accused of. That makes a bigger difference than 15 years of horrible background as a child. And that's just my experience.
Hi. So I have a question. Do you think that these issues stem from the education system? And basically us not first detecting these issues and, not doing all we can to support
was talking about, which would be to say that, that the fundamental assumption is that humans are rational moral agents. And the assumption then, of course, around education would be that we would be able, through education, to create more rational people. I'm not sure we're really rational moral agents to begin with. And my experience is I've encountered lots of PhDs who are not moral people. I'm sure you've never encountered that at college. So I'm just not sure that education is the answer, would be my own response to that. And I do think, I really was quite taken with Pete's quick and incisive way of just pointing to the fact that most of our utilitarian arguments around punishment seem to be grounded in the notion that the human agent is a rational creature at heart. And I'm not a rational creature at heart. I know that about myself.
Well, I mean, too, when we're born, we're all on an equal playing field with that. So when you're going into the education system and some people aren't being detected or some people are slipping through the cracks, that's kind of where these issues come about, and that they continue and they get to a level and they progress where, I mean, we're now facing these, larger issues when they're older.
Let me take a quick crack at that in one point you in a certain direction that you might find interesting. There was a TED Talk that we showed earlier this year, and we showed again in the spring. And this person was talking about the death penalty, and he went through all the processes of the death penalty itself, but then said, that's not really what I'm here to talk about. I'm here to talk about how do we get to the point where the process doesn't start? What could we do? And so it's that kind of question. Where could we put our resources? And you might find the things he has to say very, very interesting, because he talks about how we could intervene at each point in a person's life that might help to keep the person from getting to the point where he commits a murder. And one of the things in terms of schooling are most of the people that end up on death row, or at least a high percentage, have been in the juvenile system at some point or another. And he talks about the problems of education within the juvenile system, and talks about some states who have made efforts to try to provide good schooling within the judicial system. And all the problems, because people come and go, it's not like they're here a whole year, they come, they go, but there are some people trying to confront that. So you might find, if you look at TED Talk death penalty, I think you'd probably find some interesting ideas along those lines.
Well, I just want to follow up with what Richard said about the idea that in the federal system we have the death penalty. So my question is, so what good is it really for us as a state to abolish the death penalty? Is there a reason why we are working so hard? Because are we hoping that then it gets to the Supreme Court and then maybe be federally abolished? I mean, is that? And maybe you could address that.
The overwhelming, just to give you some numbers, basically there are thousands of state death penalty cases and hundreds of federal cases. And the likelihood of there being another death penalty case in New Hampshire, it's much, much, much more likely that it would be in state court than in federal court, because the federal criminal justice system and the set of federal crimes is relatively narrow. It has to be a particular kind of murder, although it's a lot broader than it used to be. So it's basically you have a bigger impact aiming at the states than you do at the federal system.
But I've heard that if we get a certain number of states to abolish the death penalty, that maybe that will push the Supreme Court to
maybe if we change two of the justices. Nothing's going to change until we change two of the justices. But you're right. In the cases I talked about, in Furman and in Gregg, one of the things that was considered was, and one of the things that's considered any time the Supreme Court looks at an Eighth Amendment claim and tries to decide, is this something that the Eighth Amendment bars as cruel and unusual? And so if they look at the death penalty and they see, well, 30-something states have had it on the books for a long time, and it's traditionally been used, you really can't say it's cruel and unusual. On the other hand, if there was only 2 states that had it on the books, and those 2 states used it rarely, then you would be able to say, okay, it really is rarely used now. And in fact, that's one of the arguments that was made under the state constitution that we made in Addison, was that, well, in New Hampshire, it hasn't been used since 1939, so it really has become cruel or unusual. And of course, that argument was rejected yesterday. But so, if more states abolish the death penalty, then it would perhaps prompt the Supreme Court, the change in personnel, to find it in violation of the Eighth Amendment.
Just, I've been wondering since yesterday's decision by the New Hampshire Supreme Court, and there were 22 points presented by the defense that were shot down. Or I don't know how to phrase this, but it sounds like...
That's not my favorite way to put it, but yeah. Obliterated.
My apologies. I'm sitting here thinking since yesterday, how will this affect the legislators in abolishing the death penalty if the Supreme Court is saying this is legal and it's okay? It's not something you can answer. Obviously, we don't know, but what are your feelings on that?
Well, the issues presented on appeal are, for the most part, not whether or not the legislature passed a valid law, although some of the issues address the constitutionality of the statute. They're really more about particular errors in a particular trial. So, the fact that the court upheld the death penalty statute, would signal to the legislature that it's up to them to decide. It's not in violation of the New Hampshire Constitution. But really, most of the issues were, the judge made this error when she allowed such and such evidence, or didn't allow such and such evidence, or let this person sit on the jury, or wouldn't let this other person sit on the jury. And the 22 errors that the court considered were out of, I think, 106 errors that were assigned in the original appeal, and then 22 were actually briefed. So there were more errors initially. But they really have to do with what happened during the course of the 4-month trial, much more than the particular statute and whether it's valid. However, I'm not a lobbyist in terms of the legislature. In fact, I stay away from it.
What's still pending with the court? Is something else?
Sure, I can comment on that. The appeal is a 3-part appeal, and just to really simplify it, we've completed 2 parts of the appeal, and now there's a 3rd part. The first part of the appeal was to establish what would really be the rules for the other 2 parts. And most states already have that in place, but New Hampshire hasn't had an appeal in so long that they had to have that first part. The second part of the appeal was whether there was procedural error in either the trial or the sentencing hearing, or whether any of the laws were invalid. The third part of the appeal is whether the sentence should be upheld, and in particular, whether it is disproportional to sentences in other cases. And so just to sort of flesh that out a little bit, in the first appeal, we argued about, well, what are you going to compare in the third part when you decide what's proportional and what's not proportional? What grouping of cases are you going to look at? What kinds of cases? For example, that the court ruled in that opinion that it was not valid for us to offer this case in comparison to the Brooks case, and we're not allowed to do that. That was one of the rules established for the third part of the appeal. So the sentence has not been upheld yet.
I have a question for you, and that has to do with it's my understanding that one of the elements, and you obviously will have to say if you can't comment, but one of the elements of the Addison case was that there was no proof of intent to kill, to murder the police officer. I may not be saying that correctly, but that the jury did not hold that Michael Addison formed an intention to kill. Is that correct?
Yeah, the words are really important
I'm sure
under
they
the
are.
statute, and so that's sort of half correct.
Ah,
As one of my
That's-
professors once
I'm-
told me, half correct is all wrong.
right.
So, no offense.
No, that's okay.
And I mentioned this earlier. The jury found that the prosecution did not prove that Addison had, quote, a purpose to kill.
There, okay, those are the
And
words.
that's important
Yes.
because it distinguishes us from other states.
Well, and
On the other hand, they did find that he was guilty of capital murder because under the law, purposeful conduct and knowing conduct are different. A purposeful mental state is where you have a conscious object to cause a particular result, whereas knowing mental state is sort of a less culpable state where you know something is likely to result or may result, but it's not necessarily your conscious object.
right.
So they found that when Addison fired this, and I'm not saying anything that's not stated clearly on the public record and that both sides don't agree on. When they found that Addison, turned and fired that shot, that he was acting knowingly, but they did not find that he acted with a purpose to kill.
Okay.
And that doesn't mean that they didn't believe that. It means that they found the government did not prove that factor beyond a reasonable doubt.
And the reason I ask the question is because the fact that that was not found, and yet he is still being held to the death penalty, would indicate to me that that the argument of deterrence is questionable. If we say that the intention of a capital punishment law is deterrence.
That's not what we said. That's not what the U.S. Supreme Court says.
Okay.
The U.S. Supreme Court, you said it correctly earlier, you just used a different word. The U.S. Supreme Court says a legitimate purpose of the death penalty is retribution and expression of society's outrage. I think I'm quoting it almost exactly. So retribution is the purpose.
Okay.
I mean, they would also say deterrence is another purpose, and I'm sure there's some other purposes you can come up with, but there's no doubt that the United States Supreme Court endorses retribution as a constitutionally legitimate purpose.
Okay.
So, and
That's what I was.
it's expressing outrage.
I wanted to hear you say it.
Ken?
Retribution, retribution, retribution. I love that word. Let's assume my daughter is killed, and I'm really happy with this guy. He's guilty. We've proven he's guilty. Bang. He's dead. I go to my grave happy, and people do this. They're very happy about the retribution factor. Are they naive? Are they silly? Are they stupid? Are they misguided? Are they religiously? Well, what's going on here with this stuff?
I have to say that I don't agree with that, and I've known a lot of victims, and I will tell you that I don't think they find any solace in the result. I think that many times they do want the result, and they do find, I would use the word some satisfaction in it, but I mean, I will tell you, maybe this is just my personal experience, but the families of the homicide victims are often, I'm amazed at how well they hold up. And I've actually, been on good terms with some of the families. I had one case settle because my client's family became friends with his family, and the family basically came on our side and asked for a lesser punishment. And just from my perspective, again, it's just purely personal and putting aside any sort of philosophical issues. If somebody's child is murdered, I sort of give them a free pass for whatever they want to feel. That's where I'm coming. So, I agree with you that it accomplishes nothing, and their psychologist might say being angry doesn't help you. But from my perspective, I find it really hard to fault people in that situation. They're innocent. They lost someone they cared about. There's nothing anybody can do to fix it. while I might do everything I can, or I do everything I can to prevent the death penalty, I'm not going to fault them for the feelings they have.
But I want to respond to that, which is to say, I don't fault people either for the, I mean, feelings, we just, obviously, you can't fault someone for what they're feeling. But I would suggest that one of the functions of the state in that case would be, we would be well served if the state would protect us from our own feelings.
And I think that happens every day in criminal court.
Right.
You know, in criminal court, if you look at, New Hampshire has a specific Victims' Rights Act, which the prosecutor would tell you about. And the victim has a right to be notified and a right to be heard, but the victim does not control the prosecution. The state, the law right now says the state can say, no, the victim wants too harsh a result, we're going to do something less.
Right.
We have that law. It's just politically very hard to ask the prosecutor to tell you about it.
I have a question about the Addison case. First of all, if this proposed law passes, will that have any effect on his execution or proposed execution? And secondly, is it incumbent on the governor not to comment about that case when she says that she will sign the law, but not to prevent Addison from being executed?
Definitely not going to comment on the propriety of the governor's conduct. Will it have an effect? I don't think anybody knows. In theory, the prosecution theory would be that it would not. In both Connecticut and New Mexico, the death penalty was abolished while there were people with death penalties pending. Connecticut hasn't decided whether that undermines the pending death sentences. New Mexico, the New Mexico Supreme Court has decided that it does not, and that those death sentences stand. So that's where we are.
And I'll just comment, having read that legislation, there's actually a line in there that says this act will only affect any cases that come after the act is enacted, which means that excludes the Addison case. As far as the legislature as to whether or not that would happen in the judicial process, I think Rich has probably answered that.
Well, the claim is going to be, the claim which was made in New Mexico and in Connecticut is that, okay, now you've just made it arbitrary because of when one person's case occurred, when they're going to get the death penalty, simply because they happen to be sentenced before this law was passed. That's a cruel and unusual punishment. That's arbitrary. But as I said, the New Mexico Supreme Court didn't agree with that argument.
One thing that could potentially happen with the Addison case, and this is really speculation at this point, but just kind of thinking this through. Let's assume this law passes, the death penalty repealed, so now he's our only individual. I think at this point, as Richard pointed out, once we're done with the state, then we're on to the federal appeal. So this is not going to end anytime soon. We're probably easily 5, 6, 7 years out before we hear back from the feds as to where can we go. When you look at the statistics, when you look at the opinion polls, the public's approval for the death penalty is declined every year. And even in New Hampshire, although the majority still support the death penalty, it's not by much. You might think maybe 5, 6, 7, 8 years down the road, when finally all the courts have given the blessings for the state to go ahead and execute Mr. Addison, the political climate might be such that the governor could use his or her power to, I forget the term, commute it down to life. That's certainly a possibility. I mean, one other factor you could also look in that could potentially be, one statistic that's out there that a lot of people don't know about, of all of the death penalty cases in this country, only 22% are actually, or all the people that we send to death row, only 22% are actually executed. Many of them die through, waiting for the appeals process to move forward. But now let's assume that this law passes. We're not doing any more. We only have this one case, and now we got to execute Mr. Addison. I've heard various estimates as to what it would cost to build a death chamber because we don't have it. 1.6 million is one that's out there. Personally, I kind of dispute that a little bit. I'd want to see some more, but nonetheless, we're still going to build, and there are federal regulations as to how you carry out that. You just can't roll a gurney and attach them, put an IV, and start, throwing chemicals in. There's a process that the federal government or federal laws have in how you do that, which is why we would have to build that chamber. Would there be an appetite in the legislature at that point that want to spend $1.6 million to build a facility for one person? And who knows? To me, if this passes, I kind of think that's where this whole thing may head, is either the governor commuting it or a legislature just simply saying we just can't justify $1.6 million for one guy. Who knows?
Okay, we do have time for one last question, so go ahead.
From the perspective of inmate preference, is there literature indicating that, say, for example, a 30-year-old man who might live 40 or 50 years with a sentence of life without the possibility of parole versus just being put to sleep comfortably with a needle in his arm? What's the preference?
Unfortunately, Pete isn't here anymore because he might know better than I don't know that. And personally, to me, it's irrelevant. Their choice of how they were punished for a crime. And for me, for the government to put me in a position as a member of this government, as a member of society, for whom the government speaks, the idea that they will kill in my name because the person wants to be killed, that's fine. Yeah.
I can tell you,
The reason why I asked the question was, if I recall correctly, the Oklahoma City bomber of the federal building made the decision to be abandoning the appeals process and didn't want to spend 50 years incarcerated.
Yeah. It's happening in Oregon now as well with an inmate there. But I can't recall the specific numbers, but from my reading, it's much higher than you would expect. They call them volunteers. And what they do is there has to be a hearing in court where the court says, is this person competent? Does he know what he's doing? I mean, the defendant in the case has the right to determine what appeals are pursued and what's asserted. If he says, or occasionally she says, I don't want to pursue any further appeals, I want to admit my guilt and not contest the death sentence, and the psychiatrists all say they're competent, the judge finds that he has a normal IQ, not suffering from a mental illness, et cetera, they certainly will let those go forward. So it's a surprisingly high number. It would be pretty easy to find. I think, in fact, you could probably find it at DFIC, at the Death Penalty Organization.
Just curious. Thank you.
Okay, thank you very much for coming. And again, those who